Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. We secure about $10 billion a year. Today, we have the incredible Mr. Porter, who is an expert in the state of California on construction lien law. And today's topic he will go over shortly. And without further ado, I'd like to introduce Mr. Porter.
Well, thank you, Ariella, and thank you to SunRay Construction Solutions for having me spend some time with everybody today. And I really do hope the information is helpful. Now, we only have 15 or 20 minutes or so I'm going to jump right into things. And I will do that by moving the slides along. Okay, right here we have a little legal disclaimer. And this is what this is about, is that we're going to be discussing some general principles, and there's always going to be some exceptions. We can't get into every exception. But I would say this, that when you're faced with a legal question on these issues in your business, it's always best to deal directly with your own attorney. Still, though, I've been doing this for over 30 years, and I do hope that the information is going to be helpful to you. Here's a little bit about me, and what I will say. I'm not going to go over all this stuff, but I will say that that I chaired the committee of all the attorneys in California who rewrote the laws that we're going to be discussing today, and I had my hand in drafting these personally as well. So I think I know what we're going to be talking about today, and I hope the information is helpful. So today we're going to be talking about the main release forms used in California construction, and these are used in coordination with payments that you receive on the project from the beginning of the project to the very end. Okay, some of them are dealing with when you've been paid partially. Some of them deal with when you've been paid in full. Okay, more specifically, there are 4 types of release forms that are used in construction here. Let me see if I should go on. Let me go back one. There we go. Okay, there's 4 types of release forms used in construction in California. And these forms are going to depend on the circumstances. The 4 forms are as follows. 2 of the forms are conditional releases, meaning basically that the check has been received or has been promised, but it hasn't cleared the bank. And then 2 of the forms are unconditional releases, meaning that, yeah, we got a check, we put it in the bank, and it cleared the bank. So this is unconditional, we're not going back on it. And then, of course, 2 are for progress payments, and 2 are for final payments, and we're going to go over all 4 of them. Okay, specifically, if you want more information on the forms, you can go to California Civil Code sections 8132 to 8138. And what I want to say about those statutes is that if you read them, you will see that the law in California is very specific on what you have to have in these releases. They have to say these things or they're not valid. I know that there's a lot of contractors and subcontractors as well who will use forms that don't comply with these code sections. And in my view, they're not enforceable. And that's not to their benefit, and it isn't to yours either, because it causes problems. What should happen is that everyone should use the forms as they're drafted and as they're used. I also know that there's a lot of people, contractors and owners, who will send out to people a promise of payment or even a check, and they will request that they sign an unconditional release. That's foolish, because the check could bounce, and it's not the legal way that things are done. So one main rule is that do not sign a unconditional release merely in exchange for a check or a promise for a check. I also know that there are some construction programs out there that are by companies who assure that you're going to get paid, and sometimes they will request that you send them an unconditional, and they're going to issue a check. Now, I will say that that is not the proper way to do things, but I do believe that those companies honor what they say that they're going to do. Still, I don't think it's the legal way for things to be done. So you have to be cautious. When you're doing it person to person and doing it from office to office and not using one of those programs, I would say the main rule is don't accept or don't go along with someone's request to you or demand to you to give an unconditional release in exchange for a mere promise of payment, or in exchange for a check that might bounce, because if it bounces, you have still given an unconditional release. Then you're not going to be able to put probably going to be able to put a mechanics lien, a stop payment notice, or a payment bond claim on the project. Okay, getting back into the text here where I've written note, and the 4 forms that are described in those code sections. Each of the statutes that you'll see contains this language. It'll say, the waiver and release shall be null, void, and unenforceable unless it is in substantially the following form. And then it goes on to describe the specific forms that have to be used and all the words that have to be used. Now, in addition, on the 2 unconditional releases, the following language is added. It'll say, with the text of the, quote, notice to claimant in at least as large a type as the largest type otherwise in the form. Okay, so what this basically means, and if you read the statute, you will see that you must have this language in there, and on the unconditional releases, you have to have notice to claimant in a regular size type. And for all of these, it shouldn't be in any kind of form where anything is tried to be hidden or have added language in here with other types of release language that doesn't belong in the form. So just make sure that the 4 forms that you are given follow the law, or else you're going to have to say, hey, look, you've given me this form. This form is illegal in California, in case you all didn't know who sent this to me. And I will be happy to use my own legal form, which as Ariella will note, they're available on the SunRay application, and you can do all of this online. And we also have the forms on our own website at porterlaw.com. Anyway, also finally, on this particular slide, you can look up the statutes that contain the language by going to www.leginfo.legislature.ca.gov. It's there on this page here. And if you don't write this down, you can always just Google California statutes, and eventually you'll get to the page where you can see these statutes. But the ones you want to look up is Civil Code, not to be confused with Code of Civil Procedure, but it's our California Civil Code 8132 to 8138. Okay, we'll go to the next slide here. Okay, the first type of form that we're going to look to is if a progress payment is only promised or hasn't cleared the bank. Okay, and this is going to be a conditional waiver and release on progress payment. Okay, that's the one that you would give in exchange for a check or a promise of a check. And then after the check clears, then you would give the unconditional waiver and release on progress payment. Okay, and we'll look at the forms themselves. The next type of form we're going to talk about is if a progress payment has been paid in full and the check has cleared the bank. When this happens, you're going to use an unconditional waiver and release on progress payment, and the code section is 8134, and you can look that up. And we'll look at the form itself and go over it with you in a moment. Okay. Then we get on to final payments. The third type of form is if a final payment has only been promised or it hasn't cleared the bank, then you're going to want to be using a conditional waiver and release on final payment. And you would only, yeah, that's right. Okay, if the check later clears, my apologies, then you would use the unconditional waiver and release on final payment. This one here, this conditional waiver and release on final payment, is found in Civil Code section 8136. Okay, and then the final, the granddaddy of all the forms, is if you have been paid in full and the check has cleared the bank, then you're going to want to be using an unconditional waiver and release on final payment. I will note, and we'll note it when we go over the forms, that even with this form, you can accept out certain things if you have disputes on and they don't want to pay you on. You can get paid and release everything else while leaving some issue unresolved. Okay, let me see if I can do something here. This form would be, it's generally a one-page form, but it is kind of moved on to 2 pages on the slide. My apologies. However, let's just go over the thing. Okay, so this is the conditional waiver and release on progress payment. Notice this part. Notice this document waives the claimant's lien, stop payment notice, and payment bond rights effective on receipt of payment. Okay, so what this is about, it's an important distinction to understand. You may mess up totally on these forms, okay, and as a result, you're going to lose your lien, stop payment notice, and payment bond claims. But note this, it doesn't destroy your contract claim. So you could still make a claim for breach of contract if you had to sue because someone hasn't paid you, and it is a breach of contract, and this would be evidence of that you think maybe something is released. But if you show that you have messed up on doing this form or been deceived into using a form, then you're still going to be able to sue on your contract rights. Okay, so also there's some important issues on here. There's this issue on the through date. Okay, look, you fill this out, you're the claimant, you name the customer, the job location, who the owner is, but this through date is going to be really important because you are going to give up your lien, stop payment notice, and payment bond rights for all the work you did and all the materials that you furnished to that date. Okay, then the amount of the check down a little bit further is going to be the amount of money, excluding retention, so don't worry about the retention part of it, but the amount of money that you're going to get to release all your claims to that date. Sometimes you have to push the date beyond the actual date that this is sent out because they want it to the end of the month, and then you'll have to estimate a little bit. But that seems to be okay in the industry. But you want to be sure that you're going to give up all your claims for all the work and all materials that you supplied to the project through the through date for that amount of a check, not worrying about things like retention and then who it's payable to, etc. The document doesn't affect any of the following. As noted, retentions, and then extras here for which the claimant has not received payment. That is vague, but it gives you an out if other issues come up which you can deem to be extras. And then also progress payments. I know that sometimes a progress payment is received. Let's say you're owed $50,000 at the moment of filling this out, but you already sent a progress payment or a conditional waiver and release the month before for 25. So the end result is technically you're owed 50, but this release will be for 25. And then under number 3 down here, you're going to say, yeah, last month on such and such a date, I sent one of these in for another 25. So if you consider the amount that you're going to put up here on the amount of the check plus this, that would be 25, and this would be 25, then you're covered on the 50. Okay, and then as I noted, it doesn't cover contract rights. You can still recover on contract. Then you sign it, you send it in. You don't have to have it notarized. Some people, some companies like to have it notarized, but it isn't required by the law. I would say, you know, okay, if they insist, I'd go along with it because after all you're stating is that it's true, and I would think you would put everything true in here anyway. Okay, that's the first one. The second one is very similar to the first, except it's unconditional. And that means basically that the check has cleared. Okay, everything else is pretty much the same as we discussed. There is another exception here. It doesn't affect disputed claims for extras in the amount of, and then you would put in something there that might be something along the lines of disputed change order number 6 in the amount of $3,200. So you could leave something out that is still disputed, and that way it'll still get you the release sent, and you have a disputed issue. Okay. You know what? Here, hang on a sec. My apologies. Conditional. Yeah, I apologize on something. Maybe it jumped further than I thought. Yeah, this one here is the unconditional waiver and release on progress payment. This is for the progress payment when the check has cleared. It's much like the one before. Okay, but in this case, it is unconditional on progress payment because the check has cleared. Let me move to the next one. This is final payment. Okay, you fill it out as we did before, and you have an exception down here, and this is where we get into the disputed claims in the amount of, and so you would say disputed change order number 6 in the amount of $3,200, something like that. That way you release everything on final payment, except for this disputed issue. And then you can resolve it later. You may have an arbitration clause or your contract clause, or you just work it out. But ultimately, you haven't released it, and you can still, for example, you can put a mechanics lien, a stop payment notice, or a payment bond claim on that disputed amount if you can't get it worked out within the time period for filing a mechanics lien, stop notice, or payment bond claim. And if you get to that point, Ariella can help you on that, but it's going to be generally 30, 60, 90 days after a project is completed, depending on the situation, but that's another topic. Okay, then the final one is the unconditional waiver and release on final payment. This is when you've been paid everything on the project, and down here, it doesn't release any disputed claims. You could still have a disputed claim that is not released. This appears twice in here. It should only appear once, but this is the final document. It means that I have gotten paid in full, the check has cleared, and all that remains is this issue yet to be resolved. Okay, let me see if I have any other notes in here. I will say that these 4 forms are for the payment. There are other releases. Now, there is an actual release of mechanics lien, and people often call these mechanics lien releases. Well, they're not really mechanics lien releases. They are waivers and releases on progress payment and final payment. I tend to call them statutory releases. And it is not the same as a mechanics lien release. A mechanics lien release is a release that releases an actual recorded mechanics lien, and it's a document that you would record or SunRay would record for you in the county recorder saying that I have fully or partially released my mechanics lien. So that's a different form. Also, releases in settlement agreements, those are different also. It involves Civil Code Section 1642, and they are different types of releases. Anyway, though, those are the 4 releases. They are conditional and unconditional on progress payment, and conditional and unconditional on final payment. The conditional issue relates to whether the check has cleared the bank or not. You never want to give an unconditional release unless the check has cleared the bank. Now, if anybody has any questions on any of these things that we discussed today, I would welcome you to give me a call anytime in the next week or so and say, hey, I was on the SunRay Construction Solutions seminar, and I have a question for you. For right now, with Ariella's assistance, why don't we answer any questions that any of you might have on this or any related topic? Ariella?
Yeah, right now we don't have any questions, but what happens every so often is people think about these questions as soon as the webinar is over, and they go, why didn't I ask that question? Maybe if you go to your next slide, we have our contact information. So if you ever wanted to contact Bill directly, you can certainly do that. His email address, his phone number is there. I'm not just saying that he is one of the most spectacular attorneys in the United States. He is the best in the state of California. So if you want to work with a stellar attorney who cares about your case without a question, I have known Bill for a long time, and I highly recommend him. So the last
I have to comment on that, Ariella. What do you want me to say? The check is on the way. That is so nice of you to say. I can't support those statements myself, but it's nice to hear that. I think when I get home, I'll tell my wife, a very nice lady said something very nice about me, and maybe I'll get a really nice dinner. So thank you for that.
Absolutely. And our last slide here is it's a little QR code, and feel free to take a little screenshot of that QR code, and you can give us a review and let us know what you think of our webinars. And our last slide here is, again, our contact information. And if you have any questions, we are here to answer them at any time. And Bill, thank you so much for a really great webinar on waivers and releases.
Well, thank you. And to everybody listening, I hope you all have a very nice weekend, each and every one of you. Thank you.
Thanks so much. Bye-bye.
Bye-bye.